Good day. My name is Joel Mendler. I'm a trust and estates lawyer with the New Orleans law firm of Baldwin Haspel. I specialize in assisting clients who have family members with special needs, including counseling and drafting special needs trusts. I am a past president of the Disability Rights Louisiana, formerly known as the Advocacy Center, Louisiana statewide nonprofit advocacy and protection agency for the rights of persons with disabilities. I'm grateful today to be able to share with you some important information on the topic of preserving governmental benefits using a special needs trust. This topic applies to all individuals who may have a disability and either are eligible to receive or are receiving governmental benefits, whether a child, a spouse, a sibling, a parent, or other members of your family. Although for the most part, my presentation will focus on children with disabilities. The presentation and these accompanying slides will be divided into several parts. First, some brief facts of life in dealing with planning for persons with disabilities. Secondly, an overview of public benefits available to persons with disabilities, including Social Security benefits, Medicaid, and Medicare, and differences among these programs, some of which have limits on the amount of income and assets a person may own or have to be eligible, and some governmental benefit programs that don't care at all about your financial eligibility requirements. Thirdly, what are the types of special needs trusts and how may they preserve eligibility for governmental benefits? Fourth, we're going to discuss some operational and administrative issues dealing with special needs trusts and what kind of distributions can be made from a special needs trust for the benefit of the beneficiary. And finally, at the end of the presentation, we'll be open for some questions. Okay, well, let's proceed. What are some of the facts of life in dealing with persons with disability? Well, first of all, persons with disabilities are living longer, and the needs and cost of care for a person with a disability are likely to be greater than those of non-disabled family members. Although children with special needs will require costly care after their parents have died, in my experience, few parents have provided for such costs. There's a widespread lack of estate planning among parents of children with special needs. Those who do have a plan often make mistakes by leaving money directly to their special needs child, jeopardizing means-based and means-tested governmental benefits upon which the child now depends. Another fact of life is that there's no assurance that public benefits will provide adequate resources for the individual's lifetime, and there's no guarantee that public agencies will provide lifetime services and advocacy for the person with the disability. Some of the personal care alternatives in Louisiana, which is beyond the scope of this presentation, include such legal things as a tutorship, a continuing tutorship, a limited interdiction, a full interdiction, and powers of attorney. These are legal mechanisms by which someone other than the disabled individual can make decisions, either healthcare decisions, financial decisions, or both. But that's not the topic for today. What are the main planning goals of for families with special needs members? Well, to maintain the assets that you currently own and to maximize the governmental benefits that may be available for the benefit of the person with a disability, to improve upon the quality of life of that individual who now has a longer life expectancy, using both family and governmental resources. It's often desirable to try to insulate assets from governmental reimbursement claims for services or facilities furnished to family members with a disability, and to protect those assets that you might leave to a person with a disability, or which the person with a disability already owns, from predators who might take advantage financially of the person with a disability. And finally, to set up a system to manage the funds that will be needed for the lifetime of the beneficiary. Well, with that background about the facts of life and planning goals that most of the families I counsel desire, let's talk briefly about governmental benefits. And then, as I said, we'll talk about the problem of qualifying and continuing qualification for those governmental benefits. First of all, there are two types or two broad categories of public benefits. They're so-called deed-based benefits. Those benefits are a function of having limited countable income and limited countable resources. In other words, to access need-based benefits, there are financial eligibility requirements before those benefits are available. On the other hand, there are benefits which we call entitlement programs, where income and resources generally are not counted, particularly unearned income, such as interest rates, interest, dividends, that sort of income. On the needs-based benefits, some of you may be familiar with the program called Supplemental Security Income, SSI. On the medical side, Medicaid, SNAP program, which is food assistance, HUD housing subsidies, and certain in-home support services provided by Medicaid, home and community-based services. All these programs on the left side of your screen have financial eligibility screens before the individual qualifies. On the right-hand side are those that generally don't count assets. For example, Social Security, regular Social Security retirement, Social Security disability income. On the medical side, Medicare, and certain special education programs. In other words, if I'm eligible or the individual is eligible for Social Security because they contributed to the Social Security system and they retired and they're disabled, they will get those benefits and they still can win the Louisiana lottery for millions of dollars, and that will not affect benefits based upon entitlements. There are really four basic programs of governmental public benefits: SSI, SSDI, that's Social Security, that's a benefit that the government issues from Washington to the individual or their representative payee. And on the medical side, there's Medicaid and Medicare. All four programs provide benefits for what we call the ABD, the aged, the blind, and, as this presentation is concerned about, individuals with disabilities. As I previously said, two of these programs are insurance programs: Social Security, disability income, and Medicare. That was based upon the workers' contribution to the system. And two are what is sometimes known as welfare programs, again, available to the aged, blind, and disabled, but basically the individual must be poor, must have limited countable income, limited countable resources. Well, let's talk about SSI. Some of you on this webinar may have a family member who is receiving SSI, so you're somewhat familiar with this program. This is a federal program, and it's based upon, number one, evidence that the individual, number one, is disabled. So you have a disability screen you must pass first, and the individual must be in financial need. The SSI benefit is intended for two things and nothing more: food and shelter. That's what the benefit is designed to pay for an individual with a disability who is poor. This year, the maximum SSI monthly benefit for a single individual is $794 a month. It could be lower than that because of certain issues, which we'll discuss shortly. This benefit increases every year by a cost of living adjustment, just as regular Social Security does. But $794 is the maximum benefit today. To be eligible for SSI, the individual must meet 4 tests. They must meet the definition of disability. They must meet an income test. They must meet a resource or asset test. And they must not violate what is called the transfer of resource penalty test. So what is the definition of disabled for children? Well, on your screen, you see it's a physical or mental condition or combination of impairments that will last for at least 12 months. However, once the child reaches age 18, you turn to the definition of disabled for adult individuals under the Social Security law. That definition is a little different. Under that definition, an adult is defined as being disabled if they're unable to engage in any substantial gainful activity, sometimes known as SGA, for a period that is expected to result in death or which can be expected to last for a continuous period of at least 12 months. Now, this SGA test for Social Security adults, insofar as whether they're disabled or not, is really nothing more than how much can the individual earn at a job. They look at employment earnings, and that dollar amount is the SGA amount, which again changes from year to year. This year, an adult is deemed to be disabled if, because of a mental or physical impairment, they are not expected to earn more than $1,310 per month, subject to certain offsets. Now again, we're not concerned with other income like interest or dividends or gifts. We're just interested in earnings. So a person with a disability could work at a grocery store, and as long as they are not earning more than $1,310 per month this year, they will still pass the definition of being disabled. So it's not a test that you can't have any earnings, but because of your condition, the earnings have to stay below a certain dollar amount. If the individual is receiving SSI, then if they have income, whether earned or unearned income, then that income, regardless of the type, will affect the amount of their SSI benefit. So what I said before has to do with whether the person is considered disabled or not. That was one of the tests for SSI. The next test is you have to have limited income. So if you have too much income, that's the income test, you don't qualify for SSI. The third test was that asset test. How much in the way of countable assets does the individual own? And the rule is that in order to qualify for SSI, the individual cannot own more than $2,000 worth of countable resources. Now, the word countable becomes very important because certain assets are not counted in determining whether or not the SSI applicant or recipient meets the $2,000 limit test. So here's an example of SSI eligibility on the resource test. As you see on the left-hand side, as I told you, normally an adult individual can't have more than $2,000 of countable assets. And SSI on the right-hand side of your screen counts such things as money in the bank, IRAs, certificates of deposit, a second car, stocks and bonds, cash, etc. But if you notice on the bottom right hand, SSI doesn't count a home in which the family lives, doesn't count household goods and furnishing, it does not count one car, it does not count the value of burial plots, and it does not count personal effects. Those types of assets are not counted in determining the $2,000 resource limit. But it gets more complicated than that. And that is that many children, while they're minors, will not qualify for SSI, even though they have no income and they have no resources or resources under $2,000. That's because Social Security says that we are going to deem as being available to the minor child what the parents earn and what the parents own. Because remember, SSI benefits is for food and shelter. And if the parents have earnings and resources, then Social Security says, well, we expect the parents to provide shelter and food, and they can certainly afford it for the minor child. So the minor child will not qualify for SSI during minority. However, once a child reaches age 18, assuming they're disabled, and assuming they meet the income and resource test, parental deeming of income and resources ceases. They don't count the parent's income and don't count the parent's resources in determining the child's eligibility for SSI benefits, even though the child may continue to live in the family home. And the fact that the child continues to live in the family home as an adult may have an effect on the amount of the SSI benefit, depending upon whether food and shelter is still being furnished to the adult child on a free basis. Finally, SSI has a transfer of asset penalty test. When someone has too much in the way of resources, over $2,000, and they're about to apply for SSI, or they receive a windfall when they're receiving SSI, but all of a sudden they receive some income assets which puts them over the limit, Social Security says, well, you can't just transfer those assets away. You can't gift them away. You can't gift them to other family members. You can't gift them even to the church or to other charitable organizations. If you make a gift, which they call an uncompensated transfer of assets that you have, that triggers a period of ineligibility for SSI. And it's a mathematical computation as to how many months you will be ineligible for having given away assets. And it's not only giving away assets, but if you fail to access assets, for example, if you're entitled to an inheritance, but you don't demand it, or you don't sue and receive a personal injury recovery when you could, those kinds of things, or even support payments, if you forego child support or spousal support when you're entitled to it, that's considered an uncompensated transfer of assets, triggering this penalty test for SSI. Now, that's SSI. On the other side is Social Security disability income. As I said earlier, that is not means tested. And if you've contributed to the Social Security system and you become disabled before you're eligible for normal retirement Social Security, you can collect a Social Security disability benefit. In fact, under certain circumstances, the worker's spouse or even a child may be entitled to Social Security benefits under this program based upon the working history of the parent or the spouse. As you can see, a minor child, even one who has no disability, who is dependent upon a Social Security eligible parent, that is a parent who's receiving Social Security, is entitled to a Social Security child's benefit until age 18 or 19 if a full-time student. So, for example, if a parent becomes disabled in a car accident at age 55 or 40 and is entitled to collect Social Security disability benefits because of that disability, they have a minor child, that minor child will be able to collect a benefit based upon the parent's work history. And remember, this program does not have an income limit or resource limit. The only income limit is the person who's entitled to the Social Security still can't have employment income to such an extent that they would no longer be deemed disabled under that substantial gainful activity test we discussed earlier. Even more complicated, an adult child, that is one who's over 18, whose disability manifested itself before the child reached age 22, and provided that child with a disability is unmarried, is entitled to a Social Security benefit based upon the parent's work history and Social Security benefit. That's not an SSI benefit. This is a different Social Security benefit, which is not a function of assets or resources of the adult child. It's an entitlement benefit. But the child must have been disabled prior to age 22 for that benefit to apply. Some children who are on an SSI to begin with convert to this other benefit I just discussed. So a child could start off on SSI, and then suddenly the parent retires or the parent is disabled. Well, then they may get a Social Security benefit based upon the parent's work history, which is usually greater than the SSI benefit, and again, it's not means tested. So it's not uncommon to find children starting out on SSI, even in adulthood, who are limited in the amount of income and assets they can have to continue to keep SSI, but all of a sudden the parent becomes eligible for Social Security, and the child was disabled prior to age 22, so they convert from the means-tested program SSI to the non-means tested program, Disabled Adult Child Social Security Benefit. So thus far, I have discussed what we call cash assistance Social Security programs, which are either payable directly to the individual or to the individual's representative payee. Now let's turn to medical coverage, which in many cases may be even more important than Social Security to the individual with a disability. Government medical benefits for medical care are generally payable not to the individual, but to the third-party provider of goods and services, hospitals, doctors, etc. And those two programs are Medicaid and Medicare, although there are some specialized governmental health benefits for veterans and their dependents, such as VA, and military personnel and military retirees and their families under TRICARE. However, these other health care coverages, like TRICARE, may not offer long-term care supports and services available under the Medicaid program, which I'm going to discuss in a moment. So preservation of Medicaid eligibility still may be very important to cover what other healthcare programs like VA or TRICARE don't cover. So let's take an overview of medical benefits. First of all, there's Medicaid. Like SSI, Medicaid is a means-tested program. Unlike Social Security, which is administered out of Washington, each state administers its own Medicaid program for itself under its own rules and regulations, with some general federal rules that apply to all Medicaid programs. So Medicaid comes out of Baton Rouge, the Louisiana Department of Hospitals, even though the Medicaid program in almost every state, including Louisiana, is funded largely with federal dollars, but administered out of Baton Rouge. And generally, eligibility for Medicaid is based upon the applicant being poor. Again, like SSI, having limited countable income and or limited countable resources. But it's not that simple. It never is. There are two broad Medicaid programs, and there are numerous Medicaid plans within each program. First, there's regular Medicaid. I call it regular Medicaid because this is the one we're most familiar with, and it pays for hospitals, doctors, some prescription drugs, laboratory and radiology services. In Louisiana, like many other states, any person who receives an SSI benefit, even if the benefit is only $1 because of other offsets, they automatically qualify for regular Medicaid in Louisiana, as well as long-term Medicaid, which we'll discuss in a minute. So having an SSI benefit gets you Medicaid. As a matter of fact, it's the primary passport into the Medicaid system, that is getting SSI, although there are other ways to get into the system as well. However, regular Medicaid, as I indicated, is available to individuals who have limited modified adjusted gross income. They don't necessarily have to be receiving SSI. They just have to be poor. And these programs include such programs which you may be familiar with: the Louisiana Children's Health Insurance Program, LICHIP, LAP, and the CHAMP program. So under the non-SSI program, but the limited income program, if household income in Louisiana is less than 138% of the federal poverty level, the family may qualify for regular Medicaid. It doesn't have a disability test like SSI does. You don't have to be disabled to get regular Medicaid, you just have to be poor. And it doesn't have an asset limit or resource test, so there's no $2,000 test. If you're getting regular Medicaid through SSI, since SSI has a $2,000 asset limit, getting Medicaid through SSI means you have less than $2,000. But if you just have limited income below certain poverty levels, you may qualify for regular Medicaid. The other big Medicaid program is long-term services and supports. This isn't hospital, doctors, and drugs. This is long-term care, like care in a nursing home, a mental facility, and certain what is known as home and community-based waiver services, such as the Children's Choice Waiver, where Medicaid will provide certain services in-house or in community to the individual. That's a Medicaid program for long-term care, just like nursing homes. The problem with HCBS or community services is that to qualify, there are generally long waiting lists of people trying to get benefits under that program. To get nursing home benefits through Medicaid or home and community-based services, you must have limited income and limited resources. On the income side, now we're talking about long-term Medicaid benefits. The income limit is 3 times the SSI benefit rate in effect during the year, the maximum benefit rate. So if the benefit rate right now is $794 a month, you multiply by 3, and that's the maximum income you can have to qualify for long-term Medicaid supports and services. The applicant must have limited countable resources, and like SSI, but it's a little different kind of a test, Medicaid for long-term care services has a transfer of assets penalty test. As I said, income 3 times maximum SSI rate, which in 2021 would be $2,382. But there are some special programs that even if income exceeds that limit, you you might qualify for long-term care services under Medicaid if you use the excess income over that limit for medical needs. The resource test for long-term care and support under Medicaid is $2,000. But if it's a couple who are married and one spouse, for example, needs nursing home care to be paid by Medicaid, then the spouse going into the nursing home still can't have more than $2,000 of countable assets. But the other spouse who isn't in the nursing home can, in 2021, have up to $130,380 of countable assets. And again, what's countable and not depends on the specific asset. Long-term Medicaid, like SSI, doesn't count the home unless the equity in the home is really very, very large. It doesn't count one car, doesn't count personal household furnishings and effects, doesn't count pre-need funeral, etc. And as I said, Medicaid has an asset transfer test. The rule is that when going into a nursing home or you're seeking to qualify for home and community-based services, you can't give away your assets to meet the financial criteria of the program. Otherwise, it triggers this asset penalty test. The way the penalty test works, though, is a little different in terms of how it's computed in the SSI test, but we won't go into that. You can look at the slide later. Okay, so Medicaid is a means-tested program. Medicare, on the other hand, is not means-tested. Generally, it's available only to individuals who are 65 and older. However, a person who is under age 65 who qualifies for SSDI, Social Security, either based upon their own work history, or perhaps, as we discussed earlier, one of these disabled adult children who were disabled before age 22 who become entitled to such benefit, they can get Medicare before age 65. Generally, there's a little bit of a waiting period once you convert to a Social Security disability benefit before Medicare kicks in. And again, Medicare is not means tested. You can win the lottery, you can still qualify for Medicare if you meet the other criteria. And we're familiar with Medicare. There's Part A that pays for hospitals. A lot of people think that Medicare, once they're on, will pay for nursing home care. That's a fallacy. It will not. It's Medicaid that pays for long-term nursing home care, and you have to meet those financial eligibility requirements for that kind of care. There's Part B, there's Part C, Part D, all kinds of Medicare plans available. Well, as I said, it gets complicated. So you can have a child who is disabled before age 22 who becomes entitled to the parent's Social Security benefit on the parent's Social Security work history. And as we talked about before, they probably will transition into this new benefit. So if they were getting SSI, and as you know, if you get SSI, you get Medicaid, they will transition to this other Social Security benefit and get Medicare. But they can still continue to get Medicaid as they back up to Medicare to pay for what Medicare doesn't cover, like co-payments and deductibles and certain prescription drugs. It gets even more complicated because depending upon what the Social Security benefit might be, if the Social Security benefit based upon a parent's work history is under $794, and the child was getting SSI, then the child may get both SSI and the disabled adult child benefit to bring them up to $794. For example, if the benefit on the parent's work history is only $500, well, the child needs $794. So SSI will kick in $294, and the individual will get two checks, an SSI check and a Social Security disability check. And they'll be on Medicaid and Medicare. So it gets sometimes quite confusing in families. So in summary, we talked about entitlement benefits that don't care about how much money you have, other than not earning money because then you're not disabled anymore. And that's the Social Security, disability, and Medicare. And on the other hand, there are those governmental benefit programs that do care how much income and or resources you have to qualify, like SSI, housing, SNAP, and Medicaid. So, what is the problem? Well, the problem is that if a family member is getting SSI and automatic SSI-linked Medicaid or long-term care Medicaid supports and services, their accountable resources exceed certain limits, or if their income exceeds certain limits, they will lose those valuable benefits. And how can they lose those benefits? Well, they might inherit property. Unbeknownst to them, someone has left them an inheritance, or their parents have died, and they would be entitled to an inheritance with or without a will. They may be a beneficiary under some asset that passes by beneficiary designation form that has nothing to do with a will. For example, a parent may have named a child with disability as one or more beneficiaries under a life insurance policy, a retirement benefit, an IRA, an annuity, and the parent dies, and all of a sudden, the child who was on SSI receives thousands of dollars, which kicks them off of SSI and regular Medicaid until they get down to $2,000. Depending on the amount involved, that might not be too bad. But if they're on one of these Medicaid waiting services where they have long waiting lists, getting kicked off the program and then trying to requalify may mean years of waiting before those types of benefits are reinstituted. They might have received a gift from a aunt, a grandparent. They may be receiving spousal support if it's a spouse who has a disability. And the spouse, all of a sudden, the couple divorces, and now the spouse is getting child support, which may jeopardize that spouse's means-based governmental benefits. The same with child support. The person may have applied for SSI and receives a large retroactive SSI benefit, not just the $794, but thousands of dollars, because the benefit is retroactive prior to the time the first check comes in. A person may have a disability and be receiving SSI and Medicaid and either receive or be entitled to a personal injury or workers' compensation award, which will put them over the resource limit. Or when the person applies for SSI, they may have assets already above the $2,000 accountable resource limit. For example, a savings account or what we call a Uniform Transfer to Minors Act account that was set up by a grandparent or a parent for the benefit of the child who may not have been eligible for SSI prior to age 18 because of the parent's assets and income. But now that the child has turned 18 and the parents go to Social Security and apply, and lo and behold, there's more than $2,000 in the child's name, and they'll be just turned away. So you don't meet the financial eligibility requirements. As a matter of fact, I had a situation in which the child turned 18 and the parents went to Social Security and said, we'd like to apply for our child with a disability. And they came back and said, I'm sorry, your child has too much in the way of countable resources. And the parents said, what do you mean? Our child doesn't have any assets in our child's name, no bank accounts, no assets. And they said, oh, your child has $10,000 of U.S. savings bonds. And the parents said, no, our child doesn't have any U.S. savings bonds. And the parents said, well, we went to the Internal Revenue Service and used your child's Social Security number, and they are reporting that the child has $10,000 of U.S. savings bonds. Well, long story short, it turned out that grandma had been buying U.S. savings bonds in the name of her disabled grandchild, not telling anybody about it, putting it in a shoebox under grandma's bed. And when parents went to apply for Social Security, SSI for the child, they said no, because it exceeded $2,000. Again, it's not only what you have, but it's what you could have that is counted. So failure to access assets also makes you ineligible for both SSI and long-term Medicaid services under the transfer of asset penalty. So, for example, if parents say, well, we're not going to leave anything to our disabled child, which is a big issue in Louisiana, we'll discuss in a minute, but we'll leave everything to our other children who will take care of a disabled child. Well, if that child with a disability has a right to demand a share of the parent's estate and fails to take action to do so, either in their own name or through a guardian or a curator or a tutor, that triggers the transfer of asset penalty test for those programs. So we have a problem in Louisiana. If a person dies, parents die without a will, it's considered to be dying what we call intestate. And in that situation, Louisiana writes a will for them. And generally what that will says is that children inherit everything, including a child with disability. If a surviving parent is still alive, they may have use of that inheritance, but generally, without a will, children inherit. And that causes a problem for a child on a means-tested benefit program. Well, many of my parents do write wills, and that means they die intestate. But Louisiana has a peculiar concept. Only state in the country that has this concept. It's called forced heirship. A child who is under age 23 can demand a portion of their deceased parent's estate, regardless of what the will says, if the will has not left them at least their forced share of the estate. That's any child, disabled or non-disabled, under the age of 23. Once a child reaches age 23, they are no longer a forced heir, except for a child with a disability. The Louisiana legislature, in its wisdom, has said that a child who is permanently disabled is a forced heir of their parents in their estate, regardless of their age. So actually, you could have an 80-year-old parent with a 60-year-old child who has never been disabled one day in their life, and one day before the 80-year-old parent dies, the 60-year-old child becomes disabled. That 60-year-old child is a forced heir in their parents' estate. That's how extreme it goes. It's situations that most of you are familiar with, are probably applicable to you. What that means in Louisiana is that your child with a disability that is a permanent disability is a forced heir, and you do not have basically complete testamentary freedom to leave all of your assets to your spouse or to the church or to your other children. A disabled child is entitled to a share, and a failure to assert that share after the parent's death triggers one of these transfer of asset penalties. Louisiana also has a marital portion concept for spouses, and that says basically if a spouse is disabled and receiving governmental benefits and the other spouse dies, you have to be worried as to what the disabled spouse is going to receive and satisfy Louisiana sort of like forced heirship rules in terms of how you handle that marital portion. The rule generally is if one spouse dies rich in comparison to the other, the poorest spouse can demand, regardless of what the will says, at least the marital portion in Louisiana. which would affect the surviving spouse's means-tested governmental benefits if that spouse is disabled. So what are your choices if you are a parent of a child with a disability? Well, some parents say, well, we're just going to disinherit our child because our child is eligible for governmental benefits and we'll leave our assets to others. Well, as I indicated, that's a limited option for parents in Louisiana because of our forced heirship laws. Other parents say, well, I want to leave my child with a disability as much as possible because after all, that child will probably not be self-supporting. If I have other children, they may be self-supporting, and I don't want to rely just on governmental benefits for that child who will always be in financial need for the rest of their lifetime. And the third choice that our parents struggle with is, do I leave the bare minimum to my child with a disability? That is the forced share that's required by Louisiana law, and let governmental benefits also be there as a cushion. So what do? You can leave outright gifts or bequests to a child with a disability, but we know from what I've told you, that's going to affect means-tested governmental benefits if that's what the child is receiving. Some of my clients leave gifts or bequests to third parties with the understanding that they're going to use the funds for the benefit of the disabled individual, like siblings, cousins or aunts or grandparents. And there's life insurance as well, which is very useful when you're insurable to provide for financial care and liquidity for a child with a disability who will have a lifetime need for financial support. Well, those are the problems, and I'm sure that you're not concerned about all of the problems. You want to know what the solution is. So finally, we get to special needs trust. That is one of several solutions to this problem of being over-resourced, which would jeopardize continued eligibility or future qualification for means-tested governmental benefits like SSI, Medicaid, SNAP, HUD, subsidized housing. So what is a trust? A trust is simply an agreement by which one person, who we call the trustee, holds property for the benefit of another, who we call the beneficiary, to meet some objective. Generally, trusts are used to manage and invest the assets held by the trustee for the benefit of the beneficiary, because the beneficiary lacks their own ability to handle such assets, either due to lack of maturity or disability. We often do trusts for minor children with or without a disability. We often do trusts that go beyond minority because some parents don't feel that when their child, if they die and leave assets to a child, is sufficiently mature at age 18 to handle those assets, regardless of disability or whether that child is relying on governmental benefits. So it depends. A trust is a very useful device in many, many circumstances other than talking about disability issues. But what is a special needs trust? Well, it's a type of trust that I've just talked about, but it's primarily designed for a person who has a disability and is receiving means-tested governmental benefits, so that the trust assets, the assets that are in that trust, will not be counted by those programs as income or resources in determining that child's continued eligibility for means-based public benefits. You know, public benefit programs are really designed to provide only absolute necessities. I mean, it's ridiculous. If you think that the SSI benefit of $794 a month for an adult person with a disability is sufficient to provide them with food or shelter, you are in dreamland. So these programs aren't designed to provide what the disabled adult or child needs. The purpose of the Special Needs Trust, on the other hand, as I said, is to preserve the person's eligibility for these governmental benefit programs while providing assets which can be used to supplement public benefits in order to improve the person's quality of life beyond what governmental benefits pay for. What do I mean by quality of life? What are some of the quality of life options we're talking about? Well, the trust can, for example, pay, if it has assets, for additional care providers, non-covered medical expenses, customized vans, travel and vacation, recreational activities and entertainment, special education, help with housework, clothing, professional services for the beneficiary, legal, accounting, advocacy, life care planning, can pay for Special Olympics, it can pay for housing. All these programs that aren't generally covered by SSDI or Medicaid. Now, there are two kinds of special needs trusts. One is called a third-party trust, and one is called a first-party special needs trust. And they're a little bit different, but they serve the same purpose. That is to preserve governmental benefits and to improve upon the beneficiary's quality of life. A third-party trust is not created under any kind of federal statute, and it's generally funded with assets belonging to someone other than the individual with the disability. For example, it's funded by a parent, a grandparent, a relative, or a friend. A typical third-party trust would be a trust created under a parent's will, so that when the parent dies, those assets are payable to a trust for the benefit of the disabled individual. Those assets don't belong to the disabled, for example, child, until after death. So it's being funded with the parent's assets, not assets that the disabled child already owns in their own name. And this kind of trust, as we'll compare to the first party trust in a moment, has no restriction on the beneficiary's age. The beneficiary can be 20, 60, 80. The trust doesn't have to be just for the disabled person. For example, it can be a trust for all children, one of whom might be disabled. And it has no requirement that when the disabled individual dies, that either Social Security or Medicaid are required for any kind to receive any kind of reimbursement for Medicaids that have been paid out during the lifetime of the individual. No such requirement, because we're dealing with funds that don't belong to the child, but are being placed in a third-party trust created with third-party funds. And as I said, these are usually contained in a will, but a parent could set up one of those trusts right now and put some money in it, right? Some of their money, or a grandparent can do the same. What these governmental benefit programs look to when they see those kinds of trusts is whether the assets of those trusts are really available to meet the beneficiary's food, shelter, or medical needs. And it's very important how those kinds of trusts are drafted so that they will not be counted. They can or they cannot be counted in determining eligibility. It all depends upon the language of the trust. If the trust says, this trust that I'm creating for my child and I'm funding either during my lifetime or at my death in my will, shall be used, the trustee is required to use these funds to provide food, shelter, or medical needs, then SSI will say, well, you don't need the SSI check. You have a trust where the trustee is compelled to use these funds to provide the very thing that the SSI provides the very medical care that Medicaid provides. But if the trust says, oh no, the trustee has the discretion to use these funds for food, shelter, and medical needs, but is not, quote, required to do so, and the trust contains language in it that says what the purpose of the trust is, that is to supplement these governmental benefits, not to supplant them. And in those situations, that trust would not be counted in determining eligibility for those programs. The second type of special needs trust is what we call a self-settled or first-party special needs trust. Now that differs significantly from the one I just discussed because this trust is a creature of federal statute. And it says if you meet the requirements of this statute, the assets that are in this trust will not be counted in determining eligibility for these governmental benefits programs. First requirement is this trust must be funded with the assets of the person with a disability. For example, if the individual receives a personal injury recovery and they are disabled, they can move that personal injury recovery because it belongs to them into this first party special needs trust, and it will not be counted against a $2,000 asset limit. Or if they receive an inheritance and it was because the inheritance wasn't put in a third-party trust by the parent or grandparent, or the parent died without a will, and Louisiana says, well, the child inherits outright. That inheritance now belongs outright to the child with a disability, but if all the other requirements are met, it can be moved into that third party, into this first-party trust. Remember I told you the story about the U.S. savings bonds? Well, that was now in the name of that disabled grandchild. And had the parents not consulted with a special needs attorney, they would have walked away from Social Security saying, well, we were told we're not entitled to get a benefit for our child. Wrong. Because those savings bonds could have been moved to this first party special needs trust, and the child would have been immediately eligible for the SSI benefit, having turned 18, and automatic Medicaid. So this trust is funded with assets that the child already owns, or the individual with a disability already owns. Could be a spouse, could be anybody. Secondly, the trust must be irrevocable. That means once it's changed, once it's set up, it can't be changed. So the beneficiary can't call it off and say, give me the money. Thirdly, it must be established, in other words, on the paperwork, by a parent, a grandparent, a legal guardian, a court order. That doesn't mean that's the person who has to put the money in there, because we're talking about the person with the disabilities money going into there, but that's the person who has to sign the papers. But if the beneficiary with a disability is competent, legally competent, in other words, let's say it's a physical disability, not a mental disability, and they're perfectly competent, well, then the beneficiary with the disability themselves can sign off on the trust to create on the legal papers an actual trust. Here's a biggie, though, that the beneficiary must be disabled, because we're talking about preserving disability benefits, and must be under age 65 when we set this trust up. So for most children, that's not a problem. But if someone is about to go into a nursing home, and they are 64, they can do that. But if they're 65, they can't create this trust and then say, I have less than $2,000. The trust in this case, cannot have multiple beneficiaries. The person with the disability must be the sole beneficiary of the trust. And finally, the trust must contain a provision that says when the beneficiary dies or upon earlier termination of the trust, Medicaid is entitled to be reimbursed for the cost of Medicaid benefits paid for the benefit of the beneficiary up to, but not more than, what's left in the trust at the beneficiary's death. So Medicaid will allow you to continue to be eligible for Medicaid during your lifetime, even though you have more resources than normally would be allowable because they're now in this trust. But at the end of the day, Medicaid is looking for reimbursement from the trust upon the death of the beneficiary. So what are the primary differences, as we said, between the two types of trust? The third-party trust can be funded by anyone except the beneficiary with the disability, or the beneficiary's agent, or the beneficiary's spouse. On a self-settled trust, the first-party trust, it's funded with the assets of the disabled beneficiary. And who establishes the trust? On a third-party trust, anyone except the beneficiary can establish it. On a first-party trust, a competent, legally competent beneficiary, parent, grandparent, or guardian can establish the trust. As I said, at death, it's only the first-party self-settled trust that has the Medicaid payback provision in it, not the third-party trust that might be created by a parent leaving an inheritance to a child. Well, when a child receives court-ordered child support, that's going to be considered countable income in determining whether that child meets the income test for SSI. And depending upon whether the child is over 18 or under 18, that tells you how much of the child support will be counted for SSI purposes. Generally, over 18, it's dollar for dollar. Will be counted. Now you say, well, wait a minute, I thought child support stops at age 18. Well, generally it does, but not necessarily for a child with a disability. That can go beyond age 18. So if the countable child support is more than the $794 currently, and the child is an adult with a disability, they may lose their SSI and their SSI-linked Medicaid. This can be avoided by having a special needs trust attorney prepare one of these first-party trusts, because child support is considered an asset that belongs to the child, even though it's being paid out of the pocket of the supporting parent. It's still an asset of the child. So we use one of these first-party trusts, but it must be ordered to be paid to this trust. So when you're negotiating child support for a minor child or even an adult child, it's important to talk about using a special needs trust and having a court order, having it paid into a special needs trust, which not only provides child support as a supplement and to improve quality of life over and above the SSI benefit. What about retirement benefits? If you, as a parent, have a 401k plan or an IRA, and you want to leave assets to a child with a disability, you can designate a third-party special needs trust as beneficiary for all or part of that benefit for the child with a disability. If you haven't done that and you pass away, and for example, the child with a disability inherits the IRA directly, there's still a possibility that it can be moved into a special needs trust. If you are a state or public employee, you should be aware of the survivor's benefits for a child with a disability under the LTSS program or the Teachers Retirement System program. Normally, those would be paid upon your death directly to your child with a disability. And child for those programs includes an adult. It's not a minor child. It's an adult child with a disability. And you can have those payable to a special needs trust. The old law didn't permit that. It just said in Louisiana, this special survivor's benefit for a disabled child is to be paid to the child. And when we tried to put it in a special needs trust, Baton Rouge said, sorry, the law doesn't permit it. We'd love to do it because we understand the reason for doing it. We understand that this benefit's going to jeopardize the child's governmental benefit, but that's just too bad. Nothing we can do about what the statute says on who this benefit is payable to. Well, those statutes were amended, and now if you do it the right way, those benefits can be payable to a special needs trust, and again, not jeopardize the benefits under SSI and Medicaid for a child with a disability. The same is true if you're in the military. There are disability survivors benefits for a child, and if you do it the right way, you can have those benefits paid into a trust once you pass away, if you do it the right way, so that they won't jeopardize governmental benefits. Okay, that's special needs trust. We talked about the problem, losing benefits. We talked about a solution. That is perhaps using a special needs trust, either for benefits that the child already owns or that the child may own because of something a parent, a grandparent wants to do for the child at death or during lifetime. Let's talk a little bit about these special needs trusts. One of the most difficult decisions, I think, in drafting one of these special needs trusts is the selection of a trustee and a successor trustee. That is someone who is capable of managing the trust assets and who is willing and able to assume an active role in the provision of proper personal care for a beneficiary with a disability. Someone who has knowledge of governmental benefits and the effect that trust distributions may have on means-tested benefits, and someone who would have no conflict of interest in managing these assets and would not be constantly antagonistic to the interests of the beneficiary. These special needs trusts can be what we call high-maintenance trusts. Since the trustee can't simply write a check to the beneficiary, as most trustees do in trusts, particularly if the beneficiary is incapable of handling finances, or because such outright distributions would jeopardize or reduce means-based governmental benefit programs. The selection of a wrong trustee can be as disastrous as not having a trust at all. Inexperienced or conflicted trustees can mismanage trust funds. They can spend trust funds on inappropriate items, and they can violate the rules of these governmental benefit programs. Even well-intentioned, motivated family members serving as trustee risk sabotaging a perfectly drafted special needs trust if they improperly administer the trust. So what are the choices? The choices are using a family member as trustee, a professional advisor such as your CPA or financial advisor who is willing to serve as trustee for your special needs beneficiary. Use a corporate trustee. By that I mean, for example, a bank or professional court trustees who render just trust services. Or you can have co-trustees, where two or more individuals or an individual and a corporate trustee serve jointly as trustees of one of these special needs trusts. As I said, this is a high maintenance area for a trustee. Look at all of these duties that a trustee must perform. They must administer the trust in good faith and in accordance with the terms of the trust. They owe a duty of loyalty to administer the trust solely in the interest of the beneficiary. They have to be impartial, particularly where there are more than one beneficiary in the trust. They must act as a prudent administrator. They must use reasonable care if they're going to delegate any functions. They have to preserve, keep, and control trust property. They have to keep accurate records. They're not supposed to commingle assets with their own assets. They have to enforce claims that the trust may have. They have to inform and report information to the trust beneficiary. They have a duty to invest prudently the trust assets, unless the trust provides for specific investment instructions. They're going to have to evaluate the beneficiary's physical and mental condition to know how to administer the trust. What is the beneficiary's personal care situation and current living conditions? What are the governmental benefits the beneficiary is receiving or likely to receive in the future? And how shall I administer this trust to make sure that we don't do anything to jeopardize those benefits? If I'm going to be paying for caregiving services, I better evaluate what those caregivers are doing and whether they're acting responsibly. What about the educational needs of the beneficiary? If I'm going to be paying for it, I need to know what services are available and whether the payments are worthwhile. And even though I've done this initially, I have to review all these things periodically. I can't just do it once and forget about it. I may have to work with others. There may be other fiduciaries involved in connection with this beneficiary with a disability. There could be a tutor, there could be a curator, there may be agents under a power of attorney, there may be someone else named as representative payee for Social Security. What are their authorities and how do we all interact with each other since I'm the trustee holding a lot of money? I need to know as trustee what the distribution provisions of the trust provide. And I may have to set up a distribution assessment and plan to receive distribution requests. And how do I act on them timely? Again, look at all of these duties. Well, we said that as long as these assets are held in a qualified special needs trust, they're not going to be counted. However, the ongoing administration of the special needs trust could cause a loss or reduction of SSI and Medicaid. So what we're addressing now are primarily for those of you who already have a special needs trust in place or looking in the near future of having one set up. I can draft a perfectly good, acceptable special needs trust, whether it's a third-party trust or first-party trust, with confidence that the assets will not jeopardize eligibility or continuing eligibility for SSI and Medicaid. But if the trustee over the years does not administer the trust properly, that can reduce and even cause a loss of SSI and Medicaid benefits. Generally, these special needs trusts, unless the trust instrument has some limitation in it, can pay for any, and notice the word any is in capital letters, any goods or services for the benefit of the beneficiary. to improve upon the beneficiary's quality of life over and above what the government pays for. In fact, the case on the bottom of this slide was one in which Medicaid argued that the trust disbursement was improper because the trustee for the special needs child used trust funds to buy a snowmobile, Britney Spears concert tickets, and a trip to Disney World. And guess what, folks? The court said that's perfectly okay. The government doesn't have a leg to stand on. This is a supplemental trust to improve the quality of life of that beneficiary, and those type of expenditures are absolutely permissible, and government, you can't complain about it. But what the government can complain about is a cash distribution directly from the trust to the beneficiary. If you give the beneficiary cash, or someone acting on behalf of the beneficiary cash, like a tutor or curator, SSI will offset its monthly benefit for the month the cash was distributed, dollar for dollar, because they say that cash could have been used for food and shelter, and therefore you don't need the $794 this month, irrespective of the fact that the beneficiary actually didn't use the cash distribution for food and shelter, but went out and bought some clothing or a bedroom set or a TV. The mere fact that they received the cash directly or through an agent from the Special Needs Trust can reduce or even eliminate the SSI benefit for that month, depending upon how much cash was distributed. Well, the SSI benefit was intended to pay for a person's food and shelter costs. So SSI says if you receive food and shelter from another, this is called in-kind support and maintenance, or ISM, and that too will reduce the SSI benefit. Now, when I say food and shelter from another, that could be food and shelter from a parent, or it could be an expenditure by a special needs trust for food and shelter for the benefit of a beneficiary. If a special needs trust pays rent or mortgage expenses, that's considered ISM. And on this slide are a list of 11 or 12 items that are also considered ISM, which can affect the SSI benefit, no matter who pays for it, including a special needs trust, and includes utilities and property taxes. But these are the only ones besides rent and mortgage that are counted by SSI. Certain household expenses are not counted by SSI, no matter who pays them, including a special needs trust. So, for example, the special needs trust could pay for a computer, internet services, cable TV, housekeeping services, telephone, repairs to the home, cleaning supplies. That's not considered impermissible food and shelter costs, not ISM, will not reduce the SSI benefit. But remember, you can use that special needs trust to buy that snowmobile or that Disneyland vacation. We're not talking about that. We're just talking about things that SSI counts, and food and shelter are countable, except they're limited to the ones that were on that previous slide. Now, what happens if that happens? Well, I'm not going to go through these rules, but basically, if the trust or someone else provides ISM for a beneficiary with a disability on SSI, SSI generally reduces the SSI benefit by 1/3, or $265, regardless of what the actual ISM payment was, unless the ISM payment was less than $265. So generally what that means is if the trust pays ISM, the benefit will be reduced from $794 a month to $529 a month. But remember, even if the benefit, SSI benefit, is reduced, as long as the beneficiary receives even $1 of SSI, they automatically get Louisiana regular Medicaid. Now, let's take this example. Let's say a lot of people say, well, I've been told that a special needs trust, Mr. Mendler said, it can't pay for rent. That's wrong. It can pay rent, but you've got to pay the price, and that is the 1/3 reduction in the SSI benefit rate. So let's say that reduction is $285. But what if the disabled individual can live in a very nice place at $1,500 a month? The special needs trust can pay the rent, and it may be worthwhile for it to pay the rent at $1,500 a month and only suffer a reduction in the SSI benefit of $285 a month, because certainly the beneficiary's quality of life has been greatly improved by moving to a facility where the rent was $1,500 a month. Now, I've seen trusts that were drafted that specifically say, unfortunately, thou shalt not pay trustee rent or food, which would cause a reduction in benefit. And that becomes a problem. What has to happen is that in this circumstance that I just described, you may have to go back to court because the trust was irrevocable and have the trust modified to say, oh, that's not what we really want to do, and we're perfectly willing to have the SSI benefit reduced because look at the quality of life that we're providing for the beneficiary in a much nicer place than they were before. And in 99 out of 100 cases, the judge is going to approve an amendment taking out that strict prohibition in the trust that the trustee can't pay if such a provision is contained in that trust. Can the trust reimburse family members who buy things for the beneficiary? And the answer is yes. So that if you go out as a parent and you buy clothing or medical devices, if you have a bill and you can show that that purchase was solely for the benefit of the beneficiary, and we're not talking about ISM now, yeah, the trustee, special needs trust, can write you a check to reimburse you, but you ought to maintain proper records. But again, if the SNT is paying for food and shelter and reimburses you for the cost of that, then we've got we may have an ISM problem. Well, we're talking about special needs trust and preserving benefits. Do I need a special needs trust in all circumstances? And the answer is maybe not in some very limited circumstances if you can qualify. A couple of years ago, the federal law was changed to provide for the creation of so-called ABLE accounts for individuals with a disability. And an ABLE account can be funded with up to $15,000 a year from any source, including a special needs trust. So a special needs trust can set up an ABLE account, or a parent can set up an ABLE account for an individual with a disability. But the total amount that can go into an ABLE account, and a person can only have one ABLE account from all sources, is $15,000 a year. Oddly enough, an ABLE account can pay for food, rent, and shelter, and it's not counted. It's not counted for ISM, reducing SSI benefits. So you have this disparity between a special needs trust paying for food and shelter, which will reduce SSI benefits, or a special needs trust putting up to $15,000 in an ABLE account and then have the ABLE account pay for food, rent, and shelter costs, and that won't be counted by SSI. Now, an ABLE account is part of the Internal Revenue Code, Section 529A. It comes right after Section 529 of the Internal Revenue Code, dealing with educational accounts. And basically, an ABLE account is somewhat like an IRA. You don't get a deduction from funds that are put into the account, but the account grows on a tax-deferred basis, so that if there's interest or dividends or capital gains, no taxes are paid while the funds are in the ABLE account. And if distributions are made from the ABLE account for qualifying disability expenses, those won't be taxable either, including the earnings and the increase in value of the ABLE account. Unlike an IRA, when you take the money out, normally you pay income taxes on that. What is a qualifying disability expense? Just about anything qualifies, even food, rent, and shelter, which normally would be counted by SSI. The problem with ABLE accounts, though, are the limitation. Right now, an ABLE account can only be set up for a person whose disability manifested itself before age 26. So if the person is over 26, they can't have an ABLE account. There is some legislation pending in Congress that would raise that age to 46, but that's not the law right now. So this ABLE account won't help. So let me give you an example where this might work instead of a special needs trust. Let's say the child with a disability has under $2,000 of assets and is on SSI, and all of a sudden receives $10,000 more in countable assets, cash, stocks, bonds. Well, instead of going to the expense of setting up a special needs trust with the trustee and all that other stuff, if the total amount is under $15,000, that could be transferred to an ABLE account. And you wouldn't need the special needs trust for that small amount of money. And it's very easy to set up. At the bottom of the slide is a link to the Louisiana ABLE account statute. And it has information on Louisiana ABLE and forms to set it up. Initially, ABLE accounts had to be set up in the state you lived in, but today you can set up an ABLE account in different states. So instead, you can't do 15,000 per ABLE account, but instead of using the Louisiana ABLE account, if you really wanted to, perhaps you could go to Nevada. I'm not recommending that, but that's just for your information. Can a special needs trust pay a credit card bill? Yes, it can. So if the beneficiary has a credit card, they can charge on the card and send the statement to the trust, and the trustee can pay for it. However, the trustee's got to look down that statement. And if the charge is for food and shelter, you have an ISM problem. Now you say, well, that's easy, because if the charge is at Rouse's, I know, or Whole Food or Dornax, I know that was for food. But what if the charge is for Walmart? Walmart sells food. And if you're paying that item on the credit card, you could have an ISM issue if the trust makes that disbursement. Now, what could happen is you could write a special needs trust check for all the other items, and then the disabled individual or the representative payee could use their SSI check to pay the credit card charges that represent, for example, food. It becomes very cumbersome because you can't give cash to the beneficiary without affecting SSI. For the trustee to go down to Dillard's every time the disabled beneficiary wants to buy a skirt or a pair of pants or a coat, I mean, that gets a little cumbersome. So what do you do? Well, if the trustee gives the beneficiary a regular credit card, there's nothing to prevent that beneficiary from charging food anywhere. So a regular credit card, assuming the beneficiary has competency to shop for their own, is generally not recommended. But there are special credit cards that have been developed in the last few years, like the TrueLink cards, where SSI will say that's okay. These cards can be coded or restricted in terms of what they can be used for, so that it blocks charges for food or for rent and that kind of a thing. And generally, the trustee is the owner and the administrator of the card, but the beneficiary with a disability actually holds the card and could go over, for example, to Dillard's and use that card without getting the trustee involved to buy clothing, for example. And usually there's a limit. It's like a debit card. The trustee keeps a dollar limit on how much can be charged against that card and can continually pre-fund that card. At the bottom of the slide is a link to TrueLink Financial. If you're interested in that and administering one of these trusts, that may be of interest to you. Could you give the beneficiary with a disability a gift card, a gift certificate? The answer is only if it can't be used for restaurant or grocery store. Otherwise, you have an ISM problem, and perhaps you don't want to have an ISM problem. But if the gift card or gift certificate is to a store that doesn't sell food or shelter items, like Best Buy for electronics or a flower shop, and this is a big and that card cannot be sold for cash, because that's like giving the beneficiary cash, then it won't be counted for SSI purposes. We said that in the first party trust, remember that's that trust that's funded with assets that the individual already owns, that would normally disqualify them for SSI and Medicaid, but they're now allowed by federal statute to move into a special needs trust if all the requirements of that trust are met and still continue eligibility for SSI and Medicaid. That one of those requirements was that that trust must be for the sole benefit of the beneficiary with a disability. You can't have multiple beneficiaries in that kind of trust. Under Louisiana law, even a third-party trust, if there's only a single beneficiary of that trust, the beneficiary with a disability, Louisiana trust law says that the trust must be administered for the sole benefit of the single beneficiary. So you have to be careful that the trust expenditures do not violate the sole benefit rule that would jeopardize continuing eligibility as a qualified trust for SSI and Medicaid. Now, the guidelines for SSI say that no one under the trust should be able to benefit from the trust except the beneficiary. That was very, very harsh rule. And that has been modified somewhat in the Social Security regulations to mean that the Social Security SSI beneficiary must be the primary beneficiary. And we'll talk about that in a minute. Question: when these trusts are set up, especially these first party trusts, when there's a personal injury recovery that's being moved into a trust, can we, parents say, can we build a swimming pool? Can we buy a 50-inch TV? Can we take a trip to Disney World? Well, it gets complicated again. A special needs trust can pay for a short vacation, including some food and shelter, but on a limited basis. And a temporary absence from a home on a vacation is not considered ISM because you're paying for lodgings and some restaurant food. But what about the trust paying for those items for other family members? Well, that could violate the sole benefit rule if the trust is paying for other members as well. Well, what if a parent travels with a child with a disability and provides necessary services? Can the special needs trust pay for the parent's travel and lodgings? And the answer is yes, they can. And as I said before, SSI has liberalized its rules on the sole benefit requirement by saying that absent evidence to the contrary, SSI should accept a statement from the trustee that the service assistance provided was necessary to permit the trust beneficiary to travel, and even tells SSI not to request a physician's statement concerning medical necessity or request evidence of medical training or certification by the person who's accompanying the person with a disability on that trip. That's a very good rule. Now, if the whole family goes, husband, wife, non-disabled children, and the child with a disability, and the special needs trust pays for everybody, and perhaps the argument is, well, I can't leave my other children at home if we're going to take our disabled child, you're getting into a very gray area as to whether you've gone beyond this rather liberalization of the sole benefit rule, and it's still primarily for the benefit. One caregiver, okay. The whole family, maybe not so good. And they're supposed to use a reasonableness test in evaluating, as I said, the number of people. It's a gray area. You don't know. The fact, though, SSI says that a parent or caretaker cannot afford to pay for their other children's trip or cannot leave them at home, as I indicated before, is not a consideration relevant to the sole benefit requirement. So you have to be careful. Best thing to do, of course, is if you are a trustee, consult with counsel about the specific facts of the expenditure to get an opinion as to whether it's going to violate the sole benefit rule. Because if you violate the sole benefit rule, we're not only talking about perhaps a reduction of benefit, but SSI and Medicaid can come in and say on that first party trust, it's an invalid trust. And we're going to count the assets and the income of that trust, and your child is not eligible. It's not just reducing the benefit amount for the month. We're saying this doesn't qualify. So you're off Medicaid, you're off the waiver list, you're off SSI. What about travel expenses for somebody to come to visit the trust beneficiary? Well, I'll let you read the slide, but generally it's got to be based upon some medical necessity. We have always argued as attorneys that it's great to have siblings to come to Louisiana from California to visit their disabled brother or sister. Psychologically, it's good for the beneficiary. It's meaningful for the beneficiary, and therefore the fact that the beneficiary's first party trust is paying for the airfare ought to be a good expenditure. SSI takes a little different position. You have to show that that travel was to ensure the safety or medical well-being of the trust beneficiary, which is a pretty strict rule. Okay, assuming the beneficiary has a capability, the beneficiary says, yes, I'm disabled, I have bipolar disorder, I want the trust to buy me a car. And that presents all kinds of issues about should the car be leased, should it be purchased, who should purchase it, should title be in the name of the trust, should title be in the name of the beneficiary with the disability, Can title be named in the parents, even though the trust pays for the car? Lots and lots of issues there. I'm not going to go through them, but the slide discusses who should own the car, the pros and cons, etc. Can the trust pay a parent for caregiving services for the child? I mean, we're talking again about primarily a first-party trust funded with a child's own inheritance, a personal injury recovery. Parents say, well, you know, I've been providing all this care for all these years before this trust was set up. Can the trust reimburse me for all those prior years? There, the answer is no. These retroactive payments generally are not allowed. They are deemed to have been done for love and compassion for the beneficiary, not with any expectation of being paid for those services. And there was no written contract at the time those services were rendered. How about the future, though? After the trust is funded? And the answer there is, it depends, which is a lawyer's answer. For SSI purposes, the answer is probably so, as long as the compensation is reasonable and you have a formal caregiving contract, even though the individual is a family member, including a parent. Medicaid, not so clear. If the beneficiary is receiving long-term care Medicaid services, such as home and community-based waiver services, under the Medicaid manual, Medicaid says that those payments cannot be made to a caregiver who is a spouse or a parent of the beneficiary. That's considered a transfer of asset penalty issue. Interestingly, the regulations don't prohibit a child from being a caregiver for a parent who is the beneficiary of a special needs trust. So it can go in that direction. If the trust is going to be paying for caregiving services, and we're not dealing with a parent or a spouse as the caregiver, and the child with a disability is receiving long-term Medicaid services, then somebody has to draw up a personal care contract that meets some specific requirements as to what that contract has to say, which are contained in the Louisiana Medicaid manual. Now, I talked about what Medicaid says about a parent. That, again, was long-term care Medicaid support and services. Remember, initially I told you that there were two Medicaid programs, regular Medicaid, doctors and hospitals, and then long-term Medicaid. If we're dealing only with regular Medicaid, then I think even for regular Medicaid, a special needs trust can pay a parent for caregiving services. But again, you need a personal care contract that contains these elements contained in this slide. As I said, forget that. For past caregiving services, I wouldn't try reimbursing for those. What about a house? The beneficiary says, I want a house. I want the special needs trust to pay for the house. Is that going to jeopardize my means-based governmental benefits? Again, I don't think we have much time to go into all that, but you can look at the slides. You have all the issues that we had with the car. That is, if you're going to buy the house, should it be in the special needs trust? What are the factors in determining whether a house should be purchased in the first place? What is the medical condition? What is the ongoing supports and services? Will a house be suitable now and in the future for the disabled beneficiary? Should the house be titled in the name of the beneficiary instead of the trust? What about ongoing expenses that are associated? Is there going to be funds to pay for that? Obviously, the trustee has to do a lot of thinking because this is a big expenditure with a lot of issues involved before the Special Needs Trust does buy a house. But the bottom line is that it's not a prohibited expenditure, and the house will not be counted for eligibility purposes, and if done properly, will not be counted as ISM because this is not being provided by others. It's being deemed provided by the beneficiary's own monies in their special needs trust. In that instance, if the trust purchases the house and it's not financed, but it's again complicated. Question then becomes, okay, Joel, you talked about the sole benefit rule. If we buy the house and the rest of the family lives in the house, have we violated the sole benefit requirement for first party trusts, or even the Louisiana trust requirement that says if you have a single beneficiary, the trustee is supposed to operate the trust solely in the benefit of that beneficiary, and we've got other family members living in the house? Are they going to be required to pay rent? And the answer is probably not. And if you read the Social Security instruction here, it says that, well, when we said sole benefit, we really didn't mean sole benefit. And that can be some collateral use by others. And it says that if the trust buys a house for the beneficiary to live in, that does not mean that no one else can live there. So it might not be necessary to pay rent, but again, you have to look at the facts and circumstances. When you have a lot of other adult children living in the house, in addition to the disabled beneficiary, and they really should be on their own, maybe at that point they should be paying some rent to the trust. It all depends on the facts and circumstances. The same thing with the car. When the beneficiary said they wanted the car, in the Social Security regulations, they say there's no problem buying the car for the benefit of the beneficiary. But under that sole benefit rule, we would have a problem if, for example, the car were purchased in the name of a grandson, and the grandson claimed that the car was being used to transport the grandparent to and from the doctor and to help the grandparent with groceries, and the car was paid for by the grandparent's special needs trust, but the grandson uses the car to drive to work to and from every day and on the weekends. Now the sole benefit, primary benefit, again, gets a little cloudy, and that's the same rule. I don't think there's much problem when you have a minor disabled child and you have the parents and other minor children living in the house. When the other children living in the house become adults, I think you start getting into some possible issues. But again, that's something to consult counsel about. These are all housing considerations. And that ends the presentation for today. We're going to have some questions. I appreciate your time and patience. It is my understanding that I'm going to send the slide presentation to the sponsor of the program, and they'll give you a website, and hopefully you'll be able to download those slides. Thank you very much.